discuss the cultural and educational rights as guaranteed to linguistic and religious minorities under the Constitution of India. ANS. Cultural and educational rights of minorities. Article 29 and 30 of the Constitution of India guarantees certain cultural and educational rights to the citizens of India. According to Article 29, any section of the citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. No citizen shall be denied admission into educational institution maintained by the state or receiving aid out of state funds on the grounds only religion, race, caste, language or any of them. According to Article 30, all minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. The 44th Amendment Act 1978 has inserted a new clause, 1-A, to Article 30 which provides that in making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority referred to in Clause 1, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under that clause. Clause 2 of Article 30 prohibits the state from making discrimination in the matter of grant of aid to any educational institution on the ground that it is managed by a religious minority or linguistic minority. The fundamental freedom to establish and administer educational institution by minorities guaranteed under Clause 1 of Article 30 is absolute in terms. It is not subject to any reasonable restrictions of the nature provided in Article 19 of the Constitution. All minorities, linguistic or religious, have under Article 30 an absolute right to establish and administer educational institutions of their own choice. Any law or executive direction which seeks to infringe the substance of that right under Article 30(1) would to that extent be void. The right to administer educational institutions of their choice is not, however, an absolute right. This is subject to regulation which are meant for ensuring the efficiency and smooth functioning of the minority institutions. The right to administer is not the right to maladministration. But the regulatory measures must be reasonable and should not be destructive of the minority character of the institution. In the Kerala Education Bill, AR 1958 SC 956, it was observed that a minority community can effectively conserve its language, script or culture by and through educational institutions, and therefore, the right to establish and maintain educational institutions of its choice is a necessary concomitant to the right to conserve its distinctive language, script or culture, and that is what is conferred on all minorities by Article 30(1). This right, however, is subject to Clause 2 of Article 29, which provides that no citizen shall be denied admission into any educational institutions maintained by the state or receiving aid out of state funds on the grounds only of religion, race, caste, language or any of them. In State of Bombay v. Bombay Education Society, AIR 1954 SC 561, it was observed, where a minority, like the Anglo-Indian community, which is based, inter alia, on religion and language, has the fundamental right to conserve its language, script and culture, to conserve its language, script and culture under Article 29(1), and has the right to establish and administer educational institutions of their choice under Article 30(1), Surely then there must be implicit in such fundamental right, the right to impart instruction in their own institutions to the children of their own community in their own language. To hold otherwise will be to deprive Article 29, 1, and Article 30, 1, of the greater parts of their contents. Such being the fundamental right, the police power of the state to determine the medium of instruction must yield to this fundamental right to the extent it is necessary to give effect to and cannot be permitted to run counter to it. In W. Proust v. State of Bihar, AIR 1969 SC 465, it was observed that the width of Article 30, 1 cannot be cut down by introducing in it considerations on which Article 29, 1 is based. The latter article is a general protection which is given to minorities to conserve their language, script or culture. The former is a special right to minorities to establish educational institution of their choice. This choice is not limited to institutions seeking to conserve language, script or culture, and the choice is not taken away if the minority community having established an educational institution of its choice also admits members of other communities. That is a circumstance irrelevant for the application of Article 30, 1, since no such limitation is expressed and none can be implied. The two articles create two separate rights, although it is possible that they may meet in a given case. In DAV College, Bhatinda v. State of Punjab, AIR 1971 SC 1731, the university declared that Punjabi would be the sole medium of instruction in the affiliated colleges. The court held that the right of the minority to establish and administer educational institutions of their choice includes the right to have a choice of medium of instructions also, and the university circular was directly infringing upon the rights of minorities to have instructions in Hindi as their own language and, therefore, was violative of Articles 29, 1, and 30, 1 of the Constitution. The right under Article 30, 1 is available to both the pre-Constitution and post-Constitution institutions. Recently, Supreme Court in TMA Pi Foundation v. State of Karnataka, AIR 2003 SC 355, the 11-judge constitutional bench led by Chief Justice B.N. Kirpal by 6-5 majority has held that minority educational institution not aided by the state cannot be regulated by the state. However, if an institution was aided by the state, it can be regulated by the state. The minority community has a right to establish educational institution. The state and universities can, however, provide educational qualifications for the teaching staff. The court held that the state and the university concerned will not interfere in the management of unaided minority schools so long as the education is transparent and merit is given primacy in admissions, more so in professional institutions. On the question as to who constitutes a minority, the court said the linguistic and religious minorities have to be considered on the basis of states and the population therein, as the states were reorganized on the basis of language. Explaining the extent of state control, the court said admission of students to unaided minority educational institutions where the scope for merit-based selection was practically nil could not be regulated by the state government or university, except for providing the qualifications and minimum conditions of eligibility in the interest of academic standards. However, it said this right is subject to the condition that admission to the unaided educational institution was on a transparent basis and merit was adequately taken care of. As regards to aided institutions, the court made it clear that a minority institution does not cease to be so the moment granted aid is received. An aided minority educational institution will be entitled to have the right of admission of students belonging to the minority group. At the same time, it would be required to admit a reasonable extent of non-minority students so that the rights under Article 30(1) are not substantially impaired and further, citizens' rights under Article 29(2) are not infringed. The court empowered the state governments to notify the percentage of non-minority students to be admitted. It would vary according to the types of institutions. The courses of education and other factors such as educational needs, observance of inter se merit amongst the minority groups could also be ensured.